our country is having a network problem. The infrastructure network is experiencing problem because there's no load shedding, but sometimes we lose network. In the afternoon, we got cut off because of the emergency that came up. Hence, the topic is payback time. And what's happening in our country. Legal-Politico battle, or battles are looming. I just want to deal with where I left off so that I can make everyone comfortable. But the bottom line is we are in for a high jump. Remember, I was dealing with the issue of the national speaker in my previous podcast. The last words I want to say at my previous podcast is, whatever happened on the speaker's side, therefore can use it to his advantage, because he's already been charged and he's already in custody, and he needs to urgently apply for bail. And the fact of the matter is, the matter in Johannesburg is ready for trial. They must give him copies of the docket and relevant list of witnesses they're going to use against him. It seems as if, ladies and gentlemen, I come to accept that therefore matter as well, it seems as if it's legal-political battle. Of late, Naseviwe Mapisa Nkagula allegedly said that she's ready to hand herself in from tomorrow to the authorities, whether to the police or to the NPA. She is ready to hand herself in from tomorrow. That's allegations. Could like us to deal, I can see the network is on and off. I could like us to deal with the issue of the speaker with regard to the so-called whistleblower. If that person blew the whistle of late, why should he or she didn't blow the whistle first time when she or he made payment to the speaker, as the allegation stands? And it means that it will take us back, because accordingly, the number one must issue proclamation to the SAU to investigate procurement in the Defense Force, the Department of Defense and Veterans, especially looking at the contract of this whistleblower, which means that the money must return to the state from the whistleblower and the contract declared null and void ab initio. I would like us to look at Section 105, capital letter A. This so-called whistleblower can make plea and sentence agreement with the state on the condition that will testify Naseviwe Mapisa Nkagula. Such agreement must be endorsed by the Honorable Court after it being entered between such whistleblower and the accused. whistleblower and the NPA. I beg your pardon. And such whistleblower must tell the truth or nothing else but the truth when they enter in such an agreement. Let's read the section in terms of the Criminal Procedure Act 51 of 1977 as amended. Section 105, capital letter A. Point 1. A. A prosecutor authorized thereto in writing by the National Prosecutor Director of Public Prosecutions and is very important, and an accused who is legally represented may, before the accused pleads to the charge brought against him or her, negotiate and enter into an agreement in respect of Roman figure 1, a plea of guilty by the accused to the offense charged or to an offense of which he or she may be convicted on the charge. Roman figure number 2, if the accused is convicted of the offense to which he or she had agreed to plead guilty. In brackets, double A, small letters AA, a just sentence to be imposed by the court. In brackets, BB, the postponement of the passing of sentence in terms of section 297, sub 1A. We'll have to look at that section. 297, sub 1A. Or, in brackets CC, a just sentence to be imposed by the court of which the operation of the whole or any part thereof is to be suspended in terms of section 297, sub 1B, in brackets DD, if applicable, an award for compensation as contemplated in section 300. Basically, it means that the NPA can secure that whistleblower as a witness, but besides them securing that whistleblower as a witness, they'll want that witness or whistleblower to plead guilty to the whole of the offense, part of, or the alternative, the lesser of them all. Section 105, capital letter A, in bracket small b. The prosecutor may enter into an agreement contemplated in paragraph A above, in Roman figure 1, after consultation with the person charged with the investigation of the case. So the prosecutor must consult with the investigating officer. Roman figure 2, with due regard to at least the, in brackets small letter AA, nature of and circumstances relating to the offense, small letters BB, personal circumstances of the accused, small letters CC, previous convictions of the accused, if any, and DD, in brackets, interest of the community. You must note that this section 105, capital letter A, does not as well preclude N.Speaker to enter into such agreement with the state, if these two parties so wish. In brackets, Roman figure 3, after affording the complainant or his or her representative, where it is reasonable to do so, and taking into account the nature of and circumstances relating to the offense and the interest of the complainant, the opportunity to make representations to the prosecutor regarding 1, in brackets small AA, the contents of the agreement, small letter BB, the inclusion in the agreement of a condition relating to compensation or the rendering to the complainant of some specific benefit or service in lieu of compensation for damage or peculiar loss. So, in the event that this whistleblower want to enter into such 105 capital letter A agreement, should the NPA so wish, one of the conditions may be that the whistleblower returns to the state all the monies paid with regard to the procurement contract that whistleblower received from the state. Section 105, capital letter A1, sub C, the requirements of paragraph B above, in brackets 1, Roman figure 1, may be dispensed with if the prosecutor is satisfied that consultation with the judge with the investigation of the case will delay the proceedings to such an extent that this is when the prosecutor can make his or her own decision without consulting the investigating officer. Roman figure 1 cause substantial prejudice to the prosecution, the accused, the complainant, or his or her representative. B, Roman figure 2, in brackets, affect the administration of justice adversely. Let's go to section 105, capital letter A, sub 2. An agreement contemplated in section 1 shall be in writing and shall at least state that the accused, before entering into the agreement, has been informed that he or she has the right, Roman figure 1 in brackets, to be presumed innocent until proven guilty beyond reasonable doubt. 2, Roman figure 2, to remain silent and not to testify during the proceedings. And Roman figure 3, not to be contemplated to give self-incriminating evidence. Section sub B, state fully the terms of the agreement, the substantial facts of the matter, all other facts relevant to the sentence, agreement, and any admissions made by accused. C, be signed by the prosecutor, the accused, his or her legal representative. And D, if the accused has negotiated with the prosecutor through an interpreter. It's important. If the accused has negotiated with the prosecutor through an interpreter, contain a certificate by the interpreter to the effect that he or she interpreted accurately during the negotiation and in respect of the court, just like confessions. Section 105, capital letter A3, the court shall not participate in the negotiations contemplated in subsection 1. 4, section 105, capital letter A4, A, remember number 3 is very important. The court shall not participate in the negotiations contemplated in subsection 1. For small letter A, the prosecutor shall, before the accused is required to plead, inform the court that an agreement contemplated in subsection 1 has been entered into, and the court shall, I apologize for that, this is a network problem, we got glitches, please. Certify that itself that the requirements of section 1B1, Roman figure 1 and Roman figure 2 has been complied with is the court. B, if the court is not satisfied that the agreement complies with the requirements of section 1, B, Roman figure 1 and 2, the court shall, Roman figure 1, inform the prosecutor and the accused of the reasons for non-compliance, and Roman figure 2, afford the prosecutor and the accused the opportunity to comply with the requirements consent. Section 105, capital letter Section 105, capital letter A, sub 5. If the court is satisfied that the agreement complies with the requirements of subsection 1B, Roman figure 1 and 2, the court shall require the accused to plead to the judge and order the contents of the agreement to be disclosed in court. When they enter into that agreement, it means the accused must plead. It means the accused must plead to the judge. Normally, the state can apply this Section 105 capital letter A after they have started with Section 204. I'll go to 204. I'll tell you why I say so. Section 105 capital letter A sub 6 A small letter A, after the contents of the agreement has been disclosed, the court shall question the accused to ascertain whether she confirms or he confirms and had consulted with regard to the relevant facts of the case, is happy, the agreement was entered into freely and voluntarily in his or her sound and sober senses, and without having been duly influenced, just like confessions. B, after an inquiry has been conducted in terms of paragraph A, the court shall, if the court is not satisfied that the accused is guilty of the offense in respect of which the agreement is entered into, or it appears that to the court that the accused does not admit an allegation in the charge, or that the accused has incorrectly admitted any such allegation, or that the accused has a valid defense to the charge, or for any other reason that the court is of the opinion that the plea of guilty by the accused shall not be stand, the court shall record the plea of not guilty and inform the prosecutor and the accused of the reasons therefor. C, if the court has recorded a plea of not guilty, the trial shall start. The trial shall start de novo before another presiding officer. If the Honorable Court record a plea of not guilty, the trial shall start de novo before another magistrate. There's a reason why. Because the mind of the presiding officer will have been already preoccupied of the fact that, in fact, this accused wanted to enter into a plea agreement, provided the accused may waive his her right or to be tried before another presiding officer. If the accused says, no, I'm fine, we can proceed with the trial before you, the Honorable Court, then the matter will proceed. Section 105, capital letter A, sub 7, in brackets, small letter A, if the court is satisfied that the accused admits the allegations in the charge and that he or she is guilty of the offense, in respect of which the agreement was entered into, the court shall proceed to consider the sentence agreement. B, the purposes of paragraph A, for the purpose of paragraph A, the court may, in small letter A, capital letter A, in small letter A's, direct relevant questions, including questions about the previous convictions of the accused, to the prosecutor and the accused, in brackets B, hear evidence, including evidence of evidence or statement by or on behalf of the accused or the complainant. Hear evidence, including evidence or a statement by or on behalf of the accused or the complainant before sentence. Roman figure 2 must, if the offense concerned is an offense, in small letters A, in brackets, referred to in the schedule to the Criminal Law Amendment Act 105 1997, or in brackets, small letter B, for which a minimum penalty is prescribed in the law creating the offense, have due regard to the provisions of that act or law. Section 105, capital letter A, in brackets 8. I'm sorry to take time, ladies and gentlemen, with regard to this section. I have to explain it. If the court is satisfied that the sentence agreement is just, the court shall inform the prosecutor and the accused that the court is so satisfied. Upon the court shall whereupon the court shall convict the accused of the offense charged and sentence the accused in accordance with the sentence agreement. Sorry for that network. And sentence the accused in accordance with the sentence agreement, meaning that if the state says they'll give the accused suspended sentence, that the court had to give the accused suspended sentence. B, upon being informed of the sentence which the court considers just, the prosecutor and the accused may, Roman figure 1, abide by the agreement with reference to the charge and inform the court that, subject to the right to lead evidence and to present argument relevant to sentencing, the court may proceed with the imposition of sentence. And Roman figure 2 in brackets, withdraw from agreement. The courts can, the state and the accused can enter into agreement to say, okay, we prepared for you to get a suspended sentence without a fine, option of a fine. And now the court says, no, I can give a suspended sentence, but mixed with a fine. Whatever the court can think. If the state, the prosecutor and the accused are not happy with the decision of the court, they can inform the court that they are withdrawing their plea agreement. Or one of the parties can make an application to say they intend to withdraw the plea agreement. C, if the court, the prosecutor and the accused abide by the agreement as contemplated in paragraph B sub 1, the court shall convict the accused of the sentence charged and impose sentence which it considers just. The court must consider a just sentence. D, if the prosecutor of the accused, I think I read that one. If the prosecutor or the accused withdraws from the agreement as contemplated in paragraph 1, in paragraph B, in brackets, Roman figure 1, the trial shall start de novo before another presiding officer, provided that the accused may waive his or her right to be tried before another presiding officer, then the same presiding officer can proceed with the matter. Section 105 Section 105 capital letter A sub 10. Where a trial starts de novo as contemplated in subsection 6C or 9D, A, the agreement shall be null and void and no regard shall be had or reference made to. In brackets, Roman figure 1, any negotiations, agreement, the record of the agreement in any proceedings shall be declared null and void unless the accused consents to the recording of all or certain admissions made by him or her. The prosecutor and the accused may not enter into a plea and sentence agreement in respect of a charge arising out of the same facts. The prosecutor may proceed on any charge. Section 105, capital letter A sub 11. A, the National Director of Public Prosecutions, in consultation with the Minister, shall issue directives regarding all matters which are reasonably necessary or expedient to be prescribed in order to achieve the object of this section. And any directive so issued shall be observed in the application of this section. B, directives contemplated in paragraph A above, in brackets Roman figure 1, must prescribe the procedure to be followed in the application of this section. Relating to, in brackets, small letter AA, any law, any offense referred to in the schedule to the Criminal Procedure Amendment Act of 1997, or any other offense for which a minimum penalty is prescribed in the law creating the offense. In brackets, Roman figures BB, any offense in respect of which a court has power or is required to conduct a specific inquiry, whether before or after convicting or sentencing the accused. In brackets, Roman figures CC, any offense in respect of which a court has the power or is required to make a specific order upon conviction of the accused. In brackets, Roman figure 1 may prescribe the procedure. Roman figure 2 must ensure that adequate disciplinary action shall be taken against the prosecutor who fails to comply with any directive. In brackets, Roman figure 4 must ensure that comprehensive records and statistics relating to the implementation and the application of this section are kept. C, the National Director of Public Prosecutions shall submit directives issued under this subsection. D, any directive issued under this subsection may be amended or withdrawn in like manner. Section 105, capital letter A12, the National Director of Public Prosecution shall at least once every year submit the records and statistics referred to in this subsection to Parliament. Section 105, capital letter A, sub 13. In this section, sentence agreement means an agreement contemplated in subsection 1, sub A, sub Roman figure 1, in terms of this section. I'd like us to quickly go to section 257, as I promised. It's very important to let everyone understand. Beg your pardon. A lawyer must know where to find the law and where to refer and court cases. Section 297, sub 1. Section 297, sub 1, B. Section 297, it says conditional or unconditional postponement or suspension of sentence and caution or reprimand. Subsection 1, where a court convicts a person of any offense other than an offense in respect of which any law prescribes a minimum punishment, the court may, in its discretion, in brackets A, postpone for a period of not exceeding 5 years. Let's go to Roman figure, subsection B, pass a sentence but order the operation of the whole or any part thereof to be suspended for a period not exceeding 5 years. Let's go to section 300. Remember we mentioned section 300 under this chapter 15 of the plea agreement, section 104.5, section 105, capital letter A. Section 300. I'll come to your questions or your comments. I just want to finish what I prepared for. And I apologize for that, but I had to do this. It will put everyone into context what's happening in the criminal procedure, in the criminal proceedings in South Africa. Section 300 deals with compensation. Remember, this is criminal proceedings, but a court can make an order that the victim be compensated or monies be forfeited from the accused through forfeiture units or SI units and returned to the victim. In this instance, the victim can be the state, which the state represent us as the members of the society. The money of the state belongs to us. Sorry, if someone steals or receives the state money in wrongful manner, it can be returned. And under this section, it doesn't only refer to the state, but to any victim. Even the victim is of a private person and the accused is also a private person. It's between two private persons. The court can impose this section. It's under chapter 29 and is compensation and restitution. Is section 300 up to section 301, where offense causes damage to or loss of property. It doesn't mean you have to sue that person. For example, if someone steals your phone and is being caught and breaks that phone, can pay for that damage to your phone. Or if someone assaults another person and the victim opens a case, they enter into the so-called mediation, and the accused, the suspect, agrees to pay medical expenses of the victim. Subsection 300 sub 1, where a person is convicted by a superior court, a regional court, or a magistrate court of an offense which has caused damage to or loss of property, including money belonging to some other person, the court in question may, upon the application of the injured person, upon the application of the injured person. In this instance, the SIU or forfeiture unit will represent the state, and the state is us. If this whistleblower got a contract through the speaker in the wrongful manner and benefited, and the state paid that whistleblower a lot of money, the money can be recouped. In the event that the whistleblower has used the money, then the SIU comes in and forfeiture units comes in. They attach the property, they attach everything that belongs to that whistleblower in order to recover the state money. And this must be done. Because if indeed they want to proceed and charge the speaker, they must also go after this whistleblower, must return the money. If the whistleblower got first payment, you should have blown the whistle there. Why the whistleblower have to keep quiet until the contract is awarded to such whistleblower? It raises suspicions. And therefore, I have always maintained that section 105, capital letter A, it is unconstitutional. Even section 204, it is also unconstitutional. Someone can lie in order to benefit. As I said, it says money belonging to some other person. The court in question may, upon the application of the injured person or of the prosecutor acting on the instructions of the injured person, forthwith award the injured person compensation to such damage or loss, etc. So, no stone must be left unturned until such whistleblower returns the money to the state based on the contract that whistleblower entered into with the Department of Defense and veterans. It means that contract was entered into unlawfully and in illegal manner, and that whistleblower benefited. It can be that once you have benefited, in the long run you come up and you blow the whistle, they let you go and continue the contract. Whereas ab initio, that contract was contra bonos mores and null and void. I want to compare you section 105 capital letter A with section 204. That's the tricks the state normally play when we are in criminal proceedings. And remember, this act was enacted firstly during apartheid times. Both sections, 105 capital letter A and 204. If a seasoned person, someone who's got resources, and take these sections and take the NPA to task on these sections and take them to the Constitutional Court, they'll never stand the test of the Constitution, because it means someone must lie to benefit and save their own face, just like what's happening in the sense of Mayweather murder trial. As the state submitted that in docket 636, they are not going to charge some of the people who were in the house, or they're not going to charge them under 375 until the Honorable Court makes credibility findings under 636. In the event that the credibility findings from the court against those witnesses are not affirmative, then they'll charge them. If they're affirmative, they're not going to be charged. So it means the state gives those people in the house lifeline to lie, to mislead the court in order to protect their face. But the catch is here. If the state says they're not going to call Ms. KK and some of the people in the house, how will the Honorable Court make a credibility finding? Alternatively, if the state is not going to charge them, how will the Honorable Court make a credibility finding? How will those people be brought before the Honorable Court in order for a credibility finding to be made? Now, that's where the trick comes in. The state want the defense to call some of the people in the house who are on the list of the state in the event that the state doesn't use them. When the defense calls those witnesses, it means that the defense must open their case. They must firstly call the accused. Because if the defense applies for 174 and the court denies the application, 174, it means it is charged in the middle of the trial after the state witnesses has testified and the defense are of the view that the evidence of the state is riddled with confusion and contradiction, whereby when a reasonable court looking at the evidence of the state, which is riddled with confusion and contradiction, a sober and reasonable court will not convict. And the state will only be assisted by the defense in order for the state to prove its case. Then, if Section 174 application by the defense is not granted, then the defense closes its case, doesn't call witnesses, because the defense cannot partly close its case. If the defense completely closes its case, it means even some of those witnesses who are on the list of the state and the state they didn't call them, but hand them over to the defense will not be able to call them. The only way for the defense to call them is when the defense start calling the accused into the box. Thank you. Let's look at section 204. You must look at the similarities between section 105 capital letter A and section 204. There are similarities. Section 204 states as follows, and it's a bone of contention. And that's where the state will start with any person who is a whistleblower, with any person who wants to turn the tables and become a witness, only to find out that it is the same person who persuaded the co-accused to commit an offense. This one even reminds me of a case whereby I represented some of the accused were arrested for a heist of 105 million. They committed a heist on a cash depot overnight, where they went in the depot and gave the employees inside the depot sleeping pills or sleeping drinks. After they slept, they looted the money. That was an inside job. Some of the co-accused who come from outside, they were helped by a lady who was working inside. And there were people of different races. And this lady was of another race, and co-accused from outside, they were of another race. And this lady of this other race was protected by the state and the court. They entered into, actually they made this lady a section 204 witness. Whereas is the lady who gave everyone the map and the operation how to carry out the heist. During the trial, the state used forfeiture unit and ICU to attach properties of co-accused. They attached the properties of co-accused. They never attached the property of section 204 witness, the lady who worked inside that depot. The lady stole from the employer, such a serious offense. We appealed. They never, as I said, they never attach anything from that lady. She's filthy rich wherever she is now. She's rich. And if she's wise and use that money wisely and circulated the money wisely. Process of crime. The state never attached. We made an appeal, we were not successful. We made petition, we were not successful. Once you petition in the SCA, if you are not successful in the SCA, then you petition the judge president of the SCA. The people who I was representing ran off funds and we could not take it further. They wanted cut shots. They wanted to cut the proceedings instead of going to the judge president of the SCA, who by that time was Honorable Justice, the lady who's in the Constitutional Court now. Just forget her. Her name just slept up now. Then they said to directly go to the Constitutional Court. Then the Constitutional Court dismissed it to say, Mr. Toban, you cannot have direct access. You must start from the Judge President of the SCA. Only on that basis. They never even listen to the facts. Because that's the line you must cross first before you want them to listen to the facts. Like when you make an application for agent application, you must jump the line. You must show agency first before the court can deal with the facts. Yes, ladies and gentlemen, this is a monster of a section. I don't like it at all, and it is unfair, and it renders the criminal proceedings unconstitutional and unfair. If I had millions, I should have taken this section 205 and 105 capital letter A and this 204 to constitutional court long time ago. Remember, if you want to declare certain section or law unlawful, unconstitutional, you have to start in the High Court first. You start in the High Court. If you they don't succeed, the High Court will refer you to the Constitutional Court. You cannot jump the High Court when dealing with the constitutionality of an act. You start in the High Court first, then you go to the Constitutional Court. The only matters relating to the President and the administration of Parliament, they can go directly to the Constitutional Court. Section 205, incriminating evidence by witness for prosecution. In actual fact, even in this matter of Senzo Meyiwa trial, they attempted by all means to turn accused 2 into a 204 witness. He literally refused. Even some of the leading investigating officers were saying, give us this accused. They were saying, give us this accused or accused 1 and 2. But most importantly, if we can give us accused number 1, we are happy. Like seriously now, it says 204 sub 1. Whenever the prosecutor at criminal proceedings informs the court that any person called as a witness on behalf of the prosecution will be required by the prosecution to answer questions which may incriminate such witness with regard to the offense specified by the prosecutor. So this whistleblower against the speaker can turn into 204, and the prosecution must inform the court. The court, if satisfied that such witness is otherwise a competent witness to the prosecution, shall inform such witness. You guys, you understand very well. This is the only witness the state allegedly has against the speaker. The court has to inform that witness that he is obliged to give evidence at the proceedings in question. He is obliged. 2, in Roman figure 2, that questions may be put to him which may incriminate him with regard to the offense specified by the prosecutor. And ladies and gentlemen, the word him is used here because this act was drafted to apartheid. Okay? Roman figure 3 in brackets, that he will be obliged to answer any question put to him, whether by the prosecution, the accused, or the court, notwithstanding that the answer may incriminate him with regard to the offense so specified or with regard to any offense in respect of which a verdict of guilt could be competent upon a charge relating to offense so specified. Roman figure 4, that if the answers frankly and honestly, if he answers frankly and honestly all questions put to him, he shall be discharged from prosecution. You understand that? Figure 4, that if he answers frankly and honestly all questions put to him, he shall be discharged from prosecution with regard to the offense so specified. and with regard to any offense in respect of which a verdict of guilt could have been competent specified. Remember, I talked of competent verdicts. Now you understand. Yeah. That's the Criminal Procedure Act 51 of 1977. It's mind-cracking. It means that this so-called whistleblower is the one who went, allegedly maybe is the one who went to the speaker and say, Speaker, here is take. Speaker say, no, I don't want to take. Take. The speaker takes once. Come, speaker take, man. Speaker takes twice. Why? This whistleblower didn't blow the whistle after the first interaction or transaction. But now, you want the so-called whistleblower want to turn the tables and say, want to be exonerated. In terms of corruption, there is the corrupter and the corruptee. And out there, it happens that there is a public corrupter and private corruptee. Section 204 in brackets B. Section 204 sub 1 in brackets B. Such witness shall thereupon give evidence and answer any question put to him, whether by the prosecution. Such witness shall thereupon give evidence and answer any question put to him, whether by the prosecution, the accused, or the court, notwithstanding that the reply thereto may incriminate him with regard to the offense so specified by the prosecutor, or with regard to any offense in respect of which a verdict of guilt could be competent. Don't be surprised that even this in this matter of the killing of Aka and Tips, they'll try to have a 204 witness or 105 letter A plea agreement. Don't be surprised. That's the tricks of the state. We know them very well. And they always, most of the time, for the state because of this unconstitutional act. Some of the sections in this act are unconstitutional. You must understand me very well. Not all sections in the Criminal Procedure Act are unconstitutional. Certain sections, not all sections in the Criminal Procedure Act 51 of 1977 are unconstitutional, but certain sections in this Criminal Procedure Act 51 of 1977, they are unconstitutional and inconsistent with the Constitution. Section 204, sub 2. If a witness referred to in subsection 1, in the opinion of the court, answered frankly, it's very important, answers frankly and honestly all questions put to him. You must see the tricky part of it and how this thing is brought and how this thing favors the state by all means, which renders the trial unfair. Section 2, sub A in brackets, such witness shall subject to the provisions of subsection 3. You must listen to 3 when I come there. Be discharged from prosecution to the offense so specified by the prosecutor. B, the court shall cause such discharge to be entered. Let's go to the most horrific, section 204, capital letter, section 204, sub 3. The discharge referred to in subsection 2 shall be of no legal force. The discharge referred to in subsection 2 above shall be of no legal force or effect if it is given at preparatory examination proceedings. Preparatory examination proceedings, when they are preparing for the case, it doesn't have effect. And the witness consent does not, at any trial arising out of such preparatory examination, answer, in the opinion of the court, frankly and honestly. Remember, when they enter into this 205, 204, they sit down, they negotiate, they talk, they say, okay, if you give evidence honestly and frankly, we discharge you. But now, if the witness enters there, and in the opinion of the court, the witness does not answer frankly and honestly, then this 204 doesn't apply. Hear it out. The witness consent does not, at any trial arising out of such preparatory examination, answer, in the opinion of the court, frankly and honestly, all questions put to him at such trial, whether by the prosecution, the accused, or the court. Subsection 4, small letter a. Where a witness gives evidence under this section and is not discharged from prosecution. Where a witness gives evidence under this section and is not discharged from prosecution in respect of the offense in question, such evidence shall not be admissible in evidence against him at any trial in respect of such offense, or any offense in respect of which a verdict of guilt is competent upon a charge relating to such offense. You understand that section 4 sub B, A, it says, where a witness gives such evidence under this subsection and is not discharged from the prosecution in respect of the offense in question, such evidence shall not be admissible in evidence against him. Then they must start the trial again, and they must not consider whatever he said. It's a mayhem. Section 4 sub B, that's the last section. The provisions of this section, of this subsection, shall not apply with reference to a witness who is prosecuted for perjury arising from the giving of the evidence in question, or for contravention of section 319 sub 3 of the Criminal Procedure Act of 1955, which deals with perjury. Butumelo. You see, in the matter of Senzo Mbio murder trial, this witness Tumelo, when he was testifying in the first trial, said something different from what he said in the main trial. That's perjury. Whether the first trial was nullified or not, the first trial does not nullify the fact that such witness entered the box, took an oath, and testified. Then goes to a second trial, took an oath, and testified. He remained to be under oath. Thank you, ladies and gentlemen. Let me go to our questions. I think you must be why I'm not answering you. No worries, Titi. Take your time. We need to understand this for our sakes. Yes, thank you, madam. I'm done. Yulisa, Bolani, thank you. Dimagazo, what's wrong with thank you support? I'm sending but don't see them reflected. Are you receiving it? They might be coming up because we have a network problem. Our country has a glitch. Let's hope in the coming days they'll do inform us that we have been having a infrastructure network crisis or problems. or a glitch. Dimakato Lamini, take backyard mechanic. Take a week. What's a week now? What's the problem? Who must take a week? When? Really now? Yes, I just wanted to clarify to you what you must anticipate in future in this matter between the state and Nasiviwe Mapisa Ngakula. If indeed she's going to hand herself in tomorrow or the other day after tomorrow, and they take her to court, she appears, and in the long run, the state is ready for trial, and that whistleblower will come and testify. The whistleblower must forfeit the contract. We need our money back. Period. Have you seen that this thing of politicians going to court is taking momentum? Even Jamnandas wants to take parliament to court because of he is having disagreements with his own fellow member of a political party in a standing committee. The network was gone. I was waiting for the network. And the minister is not happy with some of the reports inside that issue concerning the collapse of the Katso deal of SAA. Now, he wants to take the parliament to court not to deal with certain parts of that report. And the previous DG alleges that his signatures were forged. So they'll need to call, sorry for that, they'll need to call signature expert to deal with those issues. Now, the question that comes to my mind, what is happening in our government? Are we in a mafia state? Or our government or our country is turning into Haiti, allegedly, Puerto Rico, Haiti, Mexico, Venezuela, Colombia, or allegedly they are running our country like allegedly presidents of the United States, how they run their country. Who is in charge? To whom are the ministers accountable to? Mechanic, baguette mechanic, I hope you are not referring to me to say takes week. Takes week. I don't know what is takes week. But what I'm trying to say is, allegedly, do our ministers run departments as their own or doms or business? The network was gone again. It seems as if we are taking a wrong direction. And to be honest with you, I'm not even sure if we are ready for the elections. I want to spark a debate to say, let our elections be postponed to a specific period or specific date which the Constitution allows. Sorry for that. And I have seen that one executive member of MKP is going to appear in court tomorrow for an incitement of violence. And I'm not going to say the words he said. That was the first person in the MKP to say such words. It's a legal matter because is going to appear in court. And it's very important we be careful what we say on social media, what we consume, what we write, what we read, what we repost. Must think of the consequences. Whatever we do, whatever you do, it's got, whatever we do, it's got the consequences. So we must be careful. Honestly, you must always abide by the law, be within the parameters of the law. We cannot be perfect all the time, but always be alert. For example, if I repost a subject or content which is unlawful in terms of the laws of the Republic, it means I distribute it. I violate the Electronic Act myself as well. I can be brought to book to account. I'm spreading it. So before we say something, write something, repost something, read something, accept something and read it, you must think twice. The mere fact that you received a content that is unlawful and illegal, you read it, which is in violation of the laws of the Republic and the Electronic Act as well, and most importantly, you may be charged. Because it's very important for us to know that each and every charge, they differ on merits and the strength of such charges. Because if A is the creator of a particular content and passes it over, the person who received that content cannot be charged the same as A. And then if that person who received that content and passes it, the third receiver cannot be charged like the second person or the first person. But jokes aside, we need to be careful. It's time for elections. It's election season. We'll see many propagandas. We'll see many edited voices and audios. Artificial intelligence. We'll see them happening on social media, or even on the main media platforms. I would like us to abide by law by all means. Then don't find yourselves wanting. And it must be clear that if it happens, there was no intention on your part. Even on my side now, I take an undertaking that whatever happens, I overstep. There will be no intention over my part. Remember 4 elements of crime in South Africa. There must be act, victim, nexus, and intention. For example, that's why this platform and other platforms will talk about community guidelines. Whatever you say, whatever you write or respond must be within community guidelines. And we must not play the player, but we must play the ball. Because some of us, if you are not within community guidelines, you'll get blocked. and the network was off. I apologize for that again. If it happens that you post on this platform, on this podcast, you say something out of the ordinary, you attack the integrity of another person, you use some unwanted language, and such person see that comment, that victim has the right to take legal action against the perpetrator. So it's very important to do things within the framework of community guidelines, the law, and the Constitution. Note that all of us, we have rights. Each and every person has the right to do whatever they want to do and say whatever they want to say. But that right goes with duties. Whatever you do or say, you have the duty or duties to respect other people's rights. Hence, in our Constitution, we have limitation clause. You must remember our Constitution is very hybrid and it protects everyone. Even the Speaker, our Constitution does protect her. And it also protects the NPA. Even therefore, our Constitution protects him and it does protect the NPA. Our Constitution also protects presiding officers. You can disagree with any presiding officer in any way you want. Make sure that you don't play a presiding officer, you don't play the player, you play the ball. I just want to, before I close off, it's very important to deal with this issue of Senzo Mewa trial, whereby I appeared after TEFO and I had a debate with the previous honorable judge. I never attacked the integrity of the honorable judge or undermined the honorable judge, but I felt undermined. And when I repeated certain sentence or word twice or three times, I wanted to make sure that the honorable judge hears me and I'm able to drive my point home. It was not a form of a threat or anything towards the honorable judge, because many people think I was threatening the honorable judge. No, it's not correct. I wanted to drive a point home. You must note that, I apologize, as private practitioners, we receive instructions from clients. And by receiving instructions from clients, we are duty bound to protect the interest of the clients by all costs, especially when we receive proper financial instructions, or we enter into agreement that we will receive proper instructions, financial instructions in future. Sorry for that. A legal practitioner, whether financially instructed or not financially instructed, by mere fact appearing before a honorable judge or before the honorable court on behalf of a principal who is a client, you as an agent, you need to do your all best to protect the rights of your client, the principal. In the event that you feel that the Honorable Court didn't handle your appearance very well. The Honorable Court caused you patrimonial damages. You have the right to exercise any option you have. In casu, based on what was happening between myself and the previous honorable judge, it happened that the mandate was terminated because, in the view of the accused, they thought that they will never succeed in the matter when I was representing them because of the manner in which I was treated. Also, accused number 2, when it comes to bail application, it took time for the bail outcome to be released by the Honorable Court, which made the accused feel that he might be prejudiced because of the manner in which things against me were handled, and they cancelled a mandate, even though we had an agreement. Therefore, after that, I issued summons against the 2 presiding judges in their personal and official capacity, and also against the accused persons for loss of income, for loss of past, present, and future income. In that way, I suffered patrimonial loss because of the actions of the 2 honorable presiding officers and actions of the accused for terminating mandate. The summons are in the pipeline, and I have taken it upon myself as a good gesture and the spirit of African and Ubuntu to withdraw against the 2 honorable judges in their personal capacity. You must be able to differentiate that. I withdraw against them in their personal capacity, but I still proceed against them in their official capacity. It means that I'll proceed against JSC, Office of the Chief Justice, because they report to those offices. Since I received only 1 letter from the JSC, that was it. Hence, I would like to proceed on those bases. The accused will also remain on the summons because up to so far, they have never come to me and say on how to and on the way forward to deal with the issue. Should there be any changes, I'll inform the public. I have also taken it upon myself to withdraw against the Department of Justice, Coastal Development, and Correctional Services. I've been listening to the minister and I've been watching what is the minister doing in his work. There is good intentions upon himself to administer justice. For example, on past weeks when the Honorable Judge in the Senzo murder trial made certain remarks, racial remarks, and the following day or the night of that day, during human rights celebrations, I think it's the following day, the minister said and put it very clear that they are not going to allow other people to pull them down and say people of certain race cannot do this and people of this particular race can do this. In so saying, it's very clear and a demonstration that the Honorable Minister was condemning what happened in the Honorable Court GC, North Gauteng, Pretoria, a day before. It was so disturbing and offending because it happened a day before human rights celebrations, taking us aback. The progress we made all these years, even after 1994. It's unfortunate even the same honorable judge is the one who said he was a co-founder of BLA. Actually, it is very important that him being the co-founder was not supposed to say what the Honorable Court said. Should have waited for the legal practitioner to come back to court. The Honorable Judge should have kept quiet and waited for the relevant legal practitioner to come to court and address the issues. We suffered a lot before 1994. When David Makura was the president of SRC in the University of the North, we're embarking there. I missed by bullets several times from the state security, apartheid police, state security. I was arrested there from the campus when we were protesting at the gate. Only found out they had no charges against me. Then they blamed me of stealing a mere chocolate. It is very painful to hear such racial utterances from our own leaders. From those people, we look upon them and to learn from them. Anyway, it is water under the bridge. Relevant bodies will deal with that. And now the speaker brings someone before the court as a legal representative. The same legal representative could not argue the issue of agency. The matter was only dismissed on that fact. Should have the legal practitioner argued agency? We don't know which direction this matter should have taken. However, I'm of the view that the application was not going to be granted. It is the same. Legacy we're coming from before 1994. People were suppressed. Even now in the legal fraternity, we still suffer. That's why many people raise issues of briefs or instructions given to certain people from government institutions. As you have transpired, you have seen what happened with regard to the matter of the speaker, the person, the legal practitioner representing the speaker. What happened? The matter was dismissed because of not complying with the rules of the court with regard to agency. And now people are politicizing the matter. People are politicking. They don't see the bigger picture of the action of the speaker by taking leave from her duties in order for her not to be presumed to be interfering with whatever process. And that I must bet it will count in her favor. It's one of the facts why they want to subpoena her and not arrest her and put her in the cells overnight. Now, after this application has failed, some people, some political parties, they are saying she must be immediately charged by the NPA. Precisely the point of the NPA, what they said to the Honorable Court against the Speaker. No one must tell them when to do their work and how to do their work. So why these other political parties want to interfere in the legal process? We know very well that law, politics, and religion are linked to each other, but we must be able to draw the line. Where a matter involves political parties, it becomes legal-political battle. Where the matter involves official bearers of the government or the parliament in their official capacity, it becomes legal political battles. With due respect, I submit that this matter of the Speaker doesn't involve her to the extent that people must start politicize it. It might involve circumstances whereby she was the Minister of Defense. So we cannot separate them from politics. We cannot separate this matter from her official capacity or political position. Sorry for that, we are left with 2 minutes. Therefore, it is uncalled for other political parties to grandstand and scream, yeah, arrest her immediately. Political parties must keep their lane. Legal authorities, the NPA, they must keep their lane. Political parties must stay in their lane in terms of the principle of separation of powers. Then we'll have a democracy in our country. I thank you very much for everyone for watching. Let me just go through your questions before I close off. And good evening to everyone. Zonke Nzimande, can you help with this case of South African advocates? Can you help with the case of South African advocates? Zonke Nzimande, I don't know what you mean by the case of South African advocates. What's happening with South African advocates? Kindly DM me or comment on this broadcast after it's been uploaded, then I'll be able to reply to you. Unless you are referring to therefore, I did say that I've been trying to help him. Everything, it is in his hands and the hands of the NPA. The Magos Zameni, what is wrong with thank you? Thank you. I'm trying to, I hope, because of there's a technical glitches because of the network infrastructure. Timakazo Dlamini. No, it was a joke saying speaker take some. I don't know whether it was a joke or what. Whatever allegations against the speaker, there are allegations which must be tested in court. I don't want to mention figures because they randomly change. So we'll hear from the court. Peggy at Mechanic. What is your opinion on the new intelligence legislation? I think it's draconian. It's draconian in the sense that it will not stand the test of the Constitution, and it will violate the rights of privacy. Dimakotso Dlamini, sorry to hear that, Titi, but good luck with the sermons. No, it's fine. I understand. Thank you for that. But things happens behind closed doors in these courts and in the litigation in South Africa. If you don't stand up and fight for your rights, no one will fight for your rights. But most importantly, when you fight for your rights, you must respect the rights of your other people. You have the duty to respect the rights of other people. Dimakazo Dlamini, where is the plea agreement for Bongani and Muzi? Hey, wena useyile wait. Ujuankant. There is no plea agreement between the state and Bongani and Muzi. They ab initio denied making any incriminating statement, whether it's a plea agreement or confession. That was my instructions. Dimakazo, good evening. And this one, Yigwa. Hello, Titi. Thank you. Thank you. Welcome. It says, remember to guard your privacy and abide by our community guidelines. Ladies and gentlemen, I think we are done. We way past the time, and I appreciate very well. So I appreciate very much. So, and I would like to say thank you and good night. Next time, when you see me, I will be having my head ups and down. Yes, I'm going to cut my hair. I thank you. Good night.